the accident. His heirs intervened in her suit and have filed their own survival claims. The heirs being his wife, Miss Kimberly Gillard, and 3 minor children that are identified by their initials. As the evidence has shown through Miss Gillard's deposition testimony, the minor JKTR is not a biological child of Mr. Gillard. JKTR has brought claims. Miss Gillard and Mr. Gillard also share 2 additional children that he is the biological father of. But the intervener defendants have filed a special exception to the intervener's plaintiff's petition, paragraph 3, alleging that JKTR is a child of decedent. The evidence has shown that she is not, and that she is the natural child of their surviving spouse, but her father has been identified. The decedent, Mr. Gillard, did not have any legal obligation to provide support for JKTR. Her father was legally obligated to provide support, and in fact did provide some kind of support that is on record through her testimony. But there are no legal documents granting Mr. Gillard any legal authority to act on behalf of JKTR. So we've specially accepted to that paragraph and to her as a party in this suit.
Is special exceptions really the right way to handle this? Wouldn't this be more of a summary judgment or something handled through probate court?
I wasn't sure, but I started there because I think this has been on file for a long time, but there may be some other procedural mechanism to use.
Response?
Yes, Your Honor. Paige Aldridge on behalf of intervener plaintiffs. Adoption by estoppel is something that's being pursued through the probate court. That hasn't been determined or resolved yet, but it's still a pending matter. And so our response at this time would be that we need to get that fully fleshed out through the probate court before it can really be determined. But our understanding is that the decedent, Mr. Gillard, was taking care of this particular minor. She saw him as her dad. She didn't have visits or time really with her biological father. Don't think he really provided support or anything, even if he may have been legally obligated to. There was never an actual adoption done, but certainly this child viewed the decedent as her dad. So this is an issue that's still being worked through.
And there's a probate proceeding on this at this point?
Yes, Your Honor.
And is this the defendants in this case being kept abreast of that? Or are they part of that, I guess?
I'm not sure, Your Honor. That is on me, and I can definitely update them on what's going on in the probate matter.
I mean, I guess they're not parties in the probate matter, though, right?
Correct.
All right, response?
Yes, Your Honor, that is not that is news to me, the adoption by estoppel. But if that is something that can be, I guess, clarified or disclosed officially, or whatever information put in to plead properly in that respect to advise my clients of that, then obviously that'd be an issue. Then I'm willing to table or research another mechanism.
I'm sorry, I didn't mean to interrupt you, ma'am.
That's okay.
I'm so sorry. Ms. Eldridge, have you pled adoption by estoppel in this case?
I don't think so, Your Honor. I can definitely amend our petition to be more clear about that and to plead that specifically.
All right, I'm going to order that within 14 days that you amend the petition to state what your cause of, is it adoption by estoppel, is just to clarify this issue.
Yes, Your Honor.
So is it Miss, how do you say your name?
Sala.
Sala?
Yes.
Miss Sala, if you don't mind submitting to me a proposed order on this, it needs to say that this was heard on Zoom on December 16th. Okay. Share a copy of the proposed order with Miss Eldridge and try to get it to me by tomorrow, okay?
Okay, perfect. And you said 14 days?
Yeah, she has 14 days.
Okay, perfect. Okay, thank you, Your Honor.
All right, you guys, anything else today?
No, Your Honor.
No, Your Honor.
All right, you guys have a great rest of your day, okay?
You
Thank
do.
you.
Okay.
Okay.
All right, our next case is NH Wholesale DBA Global Financial Services. Counsel, anyone here on that case?
Yes, sir, Your Honor. Tom Culpepper and Morgan Bonney on behalf of Defendant Global Financial.
Gordon Wright and David Watson here on behalf of Plaintiff NB Wholesale.
All right. Tony, let's go on the record on DC 22-15823, NB Wholesale Inc. versus Global Financial Insurance Services. Counsel, make your appearance.
Gordon Wright and David Watson on behalf of Plaintiff NB Wholesale.
Tom Culpepper and Morgan Bonney on behalf of Defendant Global Financial.
All righty. I've read the briefing on this. I think it's a pretty interesting issue. You may proceed.
Thank you, Your Honor. I appreciate that, you've already read the briefing, so if I get a little duplicative, certainly I will move on, but I wanted to go through some of the basic facts on our motion for summary judgment, Your Honor. Global is an insurance agent who obtained a policy for NB Wholesale's inventory at a property it owned.
So let me ask this, because this was a little unclear to me from the
Yes, sir.
briefing. So they started providing services, what, in 2017? Am I recalling that correctly?
Somewhere around that time, yes, Your Honor.
And in the 2017 policy, it required fire alarms. Is that right?
Well, in actuality, the three policies at issue, well, let me back up. There is a policy that didn't require it back in, I think it's the 2017 year, but the agent's contention was the insurance company just didn't add the endorsement, and we got a statement from the customer that he was aware he needed a fire alarm. So the policies, except for 1 year, all policies always required a fire alarm on the evidence.
When this statement that he admitted that he knew he needed to get a fire alarm, when did that occur?
That was in 17, Your Honor.
Okay.
Yeah.
All right.
Yep. And we'll show that to you, Judge. That's Exhibit A. I'll put it up for you just so you see it, Judge.
Okay.
Right on.
Yes.
Go ahead.
Yes, Your Honor. That it should be coming up. I'm sorry it takes a minute. That's the statement where it says all location must have protective safeguard central station fire alarm. And so what occurred after that, Your Honor, we issued proposals to the customer. You can take that down, Morgan. We issued proposals to the customer, and in the proposals that we issued, we talked about various things, but we didn't include central station fire alarm. And in 2019, beginning in 2019, he got a policy with a company we refer to as Music, Mesa Underwriters, and that policy was then renewed for the 2020 year and the 2021 year, Your Honor. And during the course of those policies, the insurance company actually inspected the property. And that, I believe, is Exhibit, what is it?
B, the inspection lab?
B, yeah, I'll show you that the inspection.
Because all it says is my name on it.
I don't know where that's coming from, Judge.
What are you talking about?
I heard somebody talking. I don't know. Exhibit B, the insurance company Mesa Underwriters, who issued it for the 19, 20, and 21 year, inspected it as early as 19, and I believe the testimony from Mr. Nazar Ali, who was the owner, was they inspected it additional times. But the reason we're showing this one is, when they inspected it, this was the document sent to Mr. Ali and sent to the agent, and they didn't have any problem or say there was any problem with not having a central station fire alarm. that he did not apparently have. It was just,
All right, well, let me kind of look at this. So it says that the insured has 30 days to comply with the
with the
recommendation.
recommendations. Yes, sir. Yeah.
Okay. And did they do that?
They fixed this on this occasion. Yes, they did, Your Honor.
Or did they fix the central fire alarm?
Well, the inspection didn't say there was any problem with it. And that's what I'm going to get to, Your Honor. That's why the reason I'm bringing this up
Okay.
is so the insurance company inspects. They don't, you know, they certainly inspect for the protective safeguards. And in this instance, when they did their inspection, there isn't any dispute. They never told Mr. Ali that he needed a central station fire alarm. And when the agent, the procedure is that the agent would receive a copy of any recommendations or changes or deficiencies that the customer had. And this is the only one that the insurance company ever issued. And they never, in all their inspections for Mr. Ali, never said there was a problem with a central station fire alarm. So the reason I bring this up, Your Honor, and you can take it down, Morgan, is that the agent had as I showed you before, back in 17, an acknowledgement from the insured that he was aware he needed a central station fire alarm. And then the policy is inspected by the insurance company at issue in this case. They don't say there's any problem with a central station fire alarm. So as far as the agent's concerned, he has a central station fire alarm and there's no issue. In any event, what goes forward after it's renewed in 2020 and then renewed in 2021, and there's no dispute that the MB Wholesale got a copy of the policies each and every year. There was a fire in September 2021, and the insurance carrier came out and said, well, you know, they did reserve rights, and one of the reservations was on the central station fire alarm. And Mr. Nazir Ali, the owner of the MB Wholesale, testified that he had no documents supporting his fire loss. And we'll show you that testimony. It's Exhibit K. We'll put that in front of you just so we'll show it to you, Your Honor. Yeah, so here was the questioning. Did you have anything to show the insurance company that you had anything above the $2.3 million that they paid you? And he said, I had nothing. Everything I had gave to the attorney. The attorney was fighting. Yeah, that's what I'm asking you. So you had nothing to support your claim as to the value of your inventory in order to provide it to the insurance company, correct? Yes. So the insurance company, it was a $3 million policy, Your Honor, and that's what he had with Mesa for the 2019, 2020, and 2021 year. And you can take it down, Morgan. And he testified he didn't have any documentation. The insurance company, although they reserve rights, they didn't enforce the provision of the no fire alarm. They settled with him. And they settled with him for $2.3 million. And I'm going to, and that document, Judge, they marked it confidential and we put it under seal to you. It's Exhibit O, Your Honor. But I want to show you a provision of that settlement agreement.